Good morning. I'm Rohit. As a legal intern at Thomas George and Associates, on behalf of the Thomas George and Associates, I cordially welcome to the third National Virtual Moot Court Competition. We are pleased to extend a warm welcome to Mrs. Justice Shruti Shivakumar and Mr. Justice Sailesh Chauhan. I will now proceed to explain the time division granted to each counselor in a single team. Each team is allocated 30 minutes to represent their case. Each speaker will be given 50 minutes unless indicated otherwise by the team. Placards indicating time will be shown 3 minutes prior to the lapse of time allocated to speaker. And finally, once the time has lapsed, 30 seconds will be allocated for rebuttals and sub-rebuttals. We have team 19 as team 12 as petitioner and team 19 as respondent. With the permission of our learned judges, we shall commence the preliminary round of the third national virtual moot court competition. Petitioners Council, you may proceed.
Good morning, Your Lordships. Good morning, respected opponents. Am I audible and clear?
Yes, you are.
Yes, you are.
This is Council number 1 appearing on behalf of the petitioner in the case of XYZ versus the Republic of Parliamento. With Your Lordship's permission, the Council would like to brief the facts of the case. So the present case basically deals with digital assets, and that the government has not enacted any law to legalize the framework of digital assets, digital currency, non-fungible tokens, etc. And an attempt to ban this form of digital currency or assets was set aside by the Honorable Supreme Court of the Republic of Parliamento. While the government continues to contemplate its stance on cryptocurrencies and NFTs, it has in the interim implemented a new tax regime aimed at taxing the gains and profits of the income arising out of virtual digital assets at 30%. The citizens approached the Supreme Court through various writ petitions against this decision of the government and challenged the validity of the taxation imposed on digital assets and the insertion of the new section 115 BBH of the Income Tax Act. This council will be dealing with the first issue at hand, and the second council will be proceeding with the second issue and the prayer. Before moving forward with the first issue, the council would like to discuss the maintainability of the present petitions before the Honorable Supreme Court.
Yes, please.
So the citizens of Republic of Parliamento have filed various petitions under Article 32 of the Constitution of the Parliamento Republic. These multiple petitions show the general opinion and the public will of towards the violation of fundamental rights by the state, which have been enshrined in the Part 3 of the Constitution. So to this aspect, in the case of Jindal Stainless Steel versus the state of Haryana, it was held by the Supreme Court that even if the tax implemented is a compensatory tax or not, if it is causing an immediate threat or burden of carrying on a business or trade, then it can be invoked by seeking remedy under Article 32 of the Constitution. And similarly, in the case of Srimati Ujjambai versus state of UP, it was held that the fundamental rights are indeed intended not only to protect individual rights, but they are based on high public policy. The liberty of the individual and the protection of his fundamental rights are the very essence of the democratic way of this Constitution and the mode and the life adopted by the Constitution. Therefore, the general public are of a unanimous opinion that the taxing of virtual digital assets like VDAs and the NFTs, which have not yet been formally legalized, are not appropriate in the present instance.
Yes, Speaker, can you tell me where is this Jindal Street we have referred in jurisdiction?
It's before the Honorable Supreme Court, Your Lordship.
Did you mention in your petition there?
No, Lordship. This has been referred in due course for the argument purpose.
Fine. Continue.
Indeed, Your Lordship. If Your Lordship, with the leave of Your Lordship, the Council will proceed with the first issue at hand.
Yes, please.
The first issue relates to whether or not the government is justified in taxing virtual assets, digital currencies, NFTs, etc., which have not yet been legalized by the government. So it is important to have a harmonious reading of both the first and second issue at hand. The Council will be indulging with certain aspects of the first issue in relation to the second issue as it is to be construed in a harmonious manner. The Council accepts the general position of law that the Parliament has the power to impose tax upon any income irrespective of its legality. However, it is to be noted that the Parliament must apply a reasonable mind and logic before imposing any kind of tax policy. In the present case, it is contended that the Parliament has passed an unreasonable taxing policy, which is not logical in nature. So to this aspect, it is contended that the canons of taxation proposed by Adam Smith are to be considered, which are the canon of equality, the canon of certainty, the canon of economy, and the canon of convenience. So even though it is not a duty upon the parliament to consider these canons as an entirety, the parliament must, in all reasonable manner, apply the principles of these canons as well as the principles of natural justice before arriving at a taxing policy. So the same has been given due consideration and accepted by the courts of this country on multiple instances. So for example, in the case of A.A. Pyarelal versus State of Madras, the court has recognized that certainty is one of the established canons of the taxing principles. And also in the case of Konduri Buchi Rajalingam versus the State of Hyderabad, it was recognized that taxing should be economical, and it's a part of the canon of taxation. So moving forward with the argument relating to the principles of natural justice, it is contended that the parliament should adhere and should keep in mind the principles of natural justice before framing any type of taxing.
Just 1 second. Where is the case law which you have preferred, Pyarelal? In which page at least you mentioned it?
Your Lordship, since we were given a particular fixed limit of only 4 pages for arguments, we were unable to include all the cases which I am citing as reference for the argument purpose.
Those case laws which you have referred right now is not mentioned in your petition, right?
Yeah, indeed, they are not mentioned in the petition per se, because there was a limit given for 4 pages per argument.
I can see there's none other any other issue 1 which you have mentioned any other.
Yeah, indeed. With respect to issue 1 in the memorial, we have not cited any case per se, because we were unable to cite at that particular point of time due to the deadlines.
So can you please refer me once again the case name? A. Pyarelal?
A. Pyarelal versus State of Madras.
Yeah.
And the second case which I cited is Konduri Buchi Rajalingam versus State of Hyderabad for Secretary Finance Department.
Sure, please continue.
So moving on with the argument regarding the principles of natural justice, it is contended that the tax imposed must be fair and just and conforming to equity and the principles of natural justice. So to this aspect, we again have another case as reference through Thakur v. Hari Prasad versus CIT, wherein it was held that if a statutory provision can be read consistent with the principles of natural justice, the court could do so, for the legislature is presumed to intend to act according to the principles of natural justice. And to substantiate this point, in the case of Charan Lal Sahu versus Union of India, which is basically in relation with the Union Carbide Corporation case. It is another petition in that aspect. It was held that for legislation by the parliament, no principle of natural justice is attracted, provided such legislation is within the competence of the legislature. And in the present case, there is no debate against the competency of the legislature or the parliament. The parliament indeed is competent to pass any taxing laws, and therefore the competency of the parliament is not in question in the present issue. Therefore, by applying this principle in this case, we can conclude that the parliament should have taken into consideration the principle of natural justice before passing the said section 115 BBH. So moving on with the next portion of the argument, the intention of the government has to be considered with respect to the taxing policy. So by an analysis of the various RBI circulars, the finance committee report, and the proposal of the government to introduce the banning of cryptocurrency and the regulation of the virtual digital assets bill in 2019, we can come at an argument that the stance of the government was indeed to ban virtual digital assets and cryptocurrencies from time immemorial. It was only because of the decision of the Honorable Supreme Court and the Internet and Mobile Association India versus Reserve Bank of India that the Supreme Court struck down the RBI circular which prohibited the dealing in virtual digital currencies, and therefore it forced the government to take up a stance wherein it cannot ban cryptocurrencies per se. And it is further contended that the government, in order to comply with this Supreme Court judgment, took another route and went around the legal provisions and around the legal, whatever the judgment was set up, by imposing a type of a sin tax through section 115 BBH, which imposes an unreasonable and ambiguous 30% flat tax rate on all transactions related to digital currencies. Moreover, if the government was really of the opinion of regulating virtual digital assets and not banning them per se, a separate regulatory authority should have been established, and that such a vague taxing policy is detrimental towards the public. And the government is using tax as a tool to prevent the trade of the assets, which will in due course be argued by my co-counsel to be violative of the Article 14 and Article 19 1G of the Constitution. Moreover, the council also would like to reiterate the point that the 30% taxing policy obligates the preamble to the Constitution, which strives for economic justice. So placing people earning different income at the same strata by imposing a same tax regime is a gross attack on the basic principles of the Constitution as well as natural justice. So with the permission of your lordship, the council would like to reiterate an example to substantiate this point. So if we take, for example, a person who earns 2.5 lakh gross income, and in that particular sense, as a general principle, he will not be liable to any income tax due to the current income tax policies. However, if he earns 20,000 rupees out of that 2.5 lakhs as earnings out of the virtual digital assets, then in that present case, for that 20,000 amount of rupees, he will be taxed at 30% rate. And considering this position with a person who earns 50 lakh of income, who is liable to income tax as per the progressive tax of this country, and he earns the same 20,000 out of income as VDAs, he will also be liable to the same 30% tax. So therefore, the capacity to pay income tax for both of these persons is highly different. And placing them at the same strata at the 30% is a gross violation of all the canons of taxation as well as the principles of natural justice. And as a whole, it goes against the fundamental principles of the constitutional makers. So with this, the council rests its arguments for the first issue and passes over to my co-counsel. Thank you, Your Lordships.
So what is your submission on Article 268?
Your Lordships, with regard to Article 268 of the Constitution, it basically deals with that Parliament can impose only under the authority of law.
So that's what I'm asking. Where's the authority to?
Your Lordship, we are arguing on behalf of the petitioners. The authority issue should be dealt by the respondents who are the government. So it is not, it is an uncontended issue that the Parliament does have the power to impose taxing, has the power to impose taxes. What this council contends is that irrespective of the power it possesses, it should follow some basic principles and guidelines before imposing any form of tax.
Right. So have you not relied on this article in your return submissions?
No, Your Lordship, we have not relied on Article 268 per se, because we are accepting the position that Parliament does possess the authority. However, that authority should be used in a particular manner.
Okay.
You are left with 3 minutes. Are you done, or should I tell to continue the participant to petitioner to?
This council rests its case. If your lordships have any other questions, the council will be great to answer the same.
Okay.
Otherwise, my co-counsel can proceed with his arguments. It's upon the perusal of the lordships.
Judges, can we transfer to petitioner 2?
Yes, of course.
Petitioner 2, you may begin.
The council seeks permission to address the lordships.
Yes, please.
This council will be dealing with the constitutional validity of Section 115 BBH, and it contends that it is violative of the Constitution under due to various instances of unreasonable classification and its colorable exercise of power to taxation. For this, it will be relying on 3 grounds. The first topic being the disturbance of set off carry forward and the vagueness surrounding the computation of cost of acquisition. At the outset, the council would like to make it clear that there is no specific treatment or a classification of gain from VDA into anything separate or specific. Therefore, it should either be treated as a capital gain or a profit or gain from a business or a profession. If you take a gain from business or profession or a capital gain, a separate provision for set off and carry forward is given in case of a loss. However, Section 115 BBH explicitly disallows any of it. The Council therefore contends that a similarly placed income should not be treated unevenly, and the tax has been operated on a similar income in an uneven manner. Now moving on to the cost of acquisition. While the benefit of deduction of cost of acquisition is provided for the users of the VDA, there is no classification of miners. A crypto miner is one who initiates or minting of a new coin. There is a vagueness surrounding the computation of the cost of acquisition for a miner. Hence, a benefit which cannot be availed, which the other part of the users can avail, where a crypto miner cannot avail, creates certain prejudice to a certain class of users. Therefore, this council contends that it is again an unreasonable classification and is an arbitrary classification. Moving on to the second sub-issue. The council will be dealing with the flat rate of taxation, where a uniform tax rate of 30% is provided across VDAs. While it is accepted that Section 2 Clause 47A provides for a wide and a copious definition for a virtual digital assets, the same cannot be done for a taxation policy. VDS contains several digital asset classes, one being a bit cryptocurrency, another being an NFT. These possess a different and varied qualities in terms of its volatility, in terms of its quality, in terms of how transaction takes place. So a uniform tax rate is an unreasonable classification at this instance as well. So this example, I'll be differentiating with a cryptocurrency and an NFT. A cryptocurrency by its definition is a fungible token. Lordships, for example, if I possess a cryptocurrency, for example, a Bitcoin, and you, Lordship, if you possess a Bitcoin, we are of the same value at a given point in time. Whereas an NFT is a unique digital asset. I may possess NFT which is a different value, while you possess an NFT of a different value. It is a non-fungible token. And the price for a cryptocurrency is determined by the demand and supply factors, just like a normal security trading in a stock exchange. Whereas an NFT's value derives its value from its underlying asset. That underlying asset usually is of a collectible or an antique value. So these are varied varied qualities. This again was enunciated in Moot, which is the state of Kerala, where in this case, a flat tax rate of 2 per hectare was imposed by the state of Kerala. This was challenged, and the court held that a flat tax rate of 2 on land, irrespective of their quality, their yield, their income, is violating Article 14 of the Constitution, and hence was struck down. The council will be moving to the third submission, which is the colorable exercise of power by the legislation. While this council accepts the wide latitude power of the government to impose a tax, it is stated that the intention or the motive of a 30% unreasonable tax rate does not accommodate with the people's mind. As my co-counsel earlier dealt with the previous instances of how government and the legislature dealt with the BDAs via notification, via circulars, even a draft bill which proposed to ban it, the motive of the government and the legislature has been always to ban, to prevent people from engaging in flow of PDs. After the case in after the judgment in Supreme Court by the Indian Automobile Association of India versus the RBI, where the government struck down a complete ban of dealing in VC virtual digital assets, the government has now come and turned on to a high unreasonable tax rate, making the users of the VDA to part with their asset at an earlier stage. So this council contends that this is a colorable exercise of power provided by the parliament or by the constitution. This council rests his argument and seeks the permission to move on to the prayer for the petitioners.
Just can you define your definition of this colorable legislation which you're telling me right now?
Your Lordship, colorable legislation means if something is not allowed directly, it circumvents and goes around indirectly to exercise the same. So here, when the judgment in IMA versus RBI came, which completely struck down preventing in dealing with the VDAs, now the government has come up with an unreasonably high amount of 30% tax rate without enunciating the object of why 30% of tax rate came up. So it essentially is discouraging participants in participating in flow of VDAs.
Fine.
Council will be seeks permission to move the tray of petitions. Therefore, in the light of the facts presented, issues raised, arguments advanced, and authorities cited, the petitioners humbly pray that the Honorable Supreme Court of Parliament find the arguments meritorious and allow the present petitions and strike out the interim Section 115 BBH of the Income Tax Act 1961 as unconstitutional and pass any other order, decree, or judgment the Honorable Supreme Court deems fit in the interest of the justice, equity, and good conscience. All of which is humbly prayed.
Speaker 2, can you just tell me about the Article 14 restrictions against this 115 BH sections, which you're telling me?
Lordships, can you come again?
So Article 14, how is this violative against the Section 115?
The Lordship Section 115 is especially subsection 2, which explicitly disallows any kind of set off or carry forward in case of a loss in VDAs to any other income. For example, there is at the outset there is the clarification on how a specific VDA must be treated. Is it a capital gain? Is it a gain from professional business? So hence, these must either be treated as individually as a capital gain, or if it's a business, as a gain from business or profession. If you take it as capital gain or as a business or a profession, a profit from business or profession, there is a certain provision for set off and carry forward in case of a loss. It's again a profit, which is Section 72 of the Income Tax Act and Section 74, which deals with capital gains. If VDS are to be treated similarly as a capital gain or of a gain from business or profession, it should be treated similarly in terms of taxation policy as well. Subsection 2 explicitly prohibits set of provisions, which is arbitrary and is an unreasonable classification, hence violative of Article 14 of the Constitution.
Thank you.
Courtmaster, the remaining time we'll be utilizing for the rebuttal rounds at the end of the respondents' arguments.
Can you pardon?
The remaining 2-3 minutes we'll be utilizing for the rebuttal rounds.
Okay.
That's to be noted. Thank you.
Judges, should I transfer the argument to the respondents?
Yes, please.
Okay. Respondents, you may begin now.
Am I audible?
Yes.
Much obliged.
Please start.
May it please this honorable court, Business Council, appearing on behalf of respondents in the case of XYZ versus Republic of Parlamento. If your lordship permits, may I please state the facts of the case in hand?
Please go ahead.
Much obliged, your lordship, ladyship. The Republic of Parlamento did not enact any law to legalize the framework of digital assets, digital currency, non-fungible tokens, etc. An attempt to ban this form of digital currency or digital assets was set aside by the Honorable Supreme Court of Republic of Parlamento. While the government continues to contemplate its stance on cryptocurrencies and NFTs, it has in the interim implemented a new tax regime aimed at taxing gains or income from virtual digital assets at 30%. That the citizens of the nation were perplexed as when there is no law legalizing the digital currency, digital assets, NFTs, etc., the decision is no tax gains from the same is unreasonable. If your lordship permits, may I please move on to my issues?
Yes.
Much obliged, your ladyship. Issue 1 is whether or not the government is justified in taxing digital currency, digital asset, NFTs, etc., which is not legalized. And issue 2 is whether or not Section 115 BBH of income tax is violative to the Constitution of India. Your leadership, I will be dealing with the first issue in 15 minutes, and my co-counsel will be arguing the second issue in 12 minutes, reserving 3 minutes for rebuttals. May I please move on to my arguments, Your Lordship, Leadership?
Yes, please.
Much obliged, Your Leadership. The respondent submits the government of Republic of Parliament is justified in taxing digital currency, digital asset, NFTs, etc. The government of Republic of Parlamento had in 2012 retrospectively amended the Income Tax Act. This was in response to a Supreme Court verdict which was held that Vodafone cannot be taxed for a 2007 transaction that involves its purchase of 67% of stake in Hood Session Wempow for $11 billion, due to which the government brought a sovereign right to taxation. The government of Republic of Parlamento have the right to impose taxation under Article 246 of the Constitution, subject matter to laws made by Parliament and legislatures of the state. As Article 246 of the Constitution gives power to the Parliament and the legislature of states in making laws with respect to uh, any of the matters enumerated in list 1, 2, and 3 in the 7th schedule of the Constitution. And when it comes to an purpose of the legality of the asset and taxation, Section 224 of the IT Act 1961 gives an inclusive definition of the word income. The expression of the income is very wide, and objective of the Income Tax Act is to bring one to tax income. The Income Tax Act is to bring one to tax income. It is to be given an extension meaning in Dr. Ta Qureshi versus Commissioner of Income Tax. The Supreme Court held that the cases are not are to be decided by the courts on legal principles and not on moral views. Law is different from morality. The primary function of the act is to bring the income of various kinds into a tax net. The income tax authorities are not concerned about the manners or means of acquiring income. The income might have been earned illegally or by resorting to unlawful means. Any legality tainted with the earnings has no bearing on its taxability. And hello, am I
Yes,
audible?
counsel. Yes, please continue.
Sorry for the disturbance, Your Lordship. May I continue, Your Lordship?
Yes, please.
Much obliged, Your Lordship. I was on the legality of the assets and taxation, and now I'm on legalization framework of the digital assets. There are many reasons as to why the framework of the digital assets are not legalized, such as loss of control due to decentralization. Government has the power to control traditional currencies. They can change the monetary policy to run the economy. There can They can track the movement of money in the economy, which earns profits and collect tax accordingly. They can also track criminal or fraudulent activities performed with the fiat currencies easily. Control over the currency gives the government power to influence the economy, create a monetary policy, foster financial transactions, etc. With the inception of Bitcoin, the government loses control over the currency system due to decentralization. Is taking an example of Bitcoin, underlying technology does not allow any central authority or any transaction. The government cannot regulate the monetary policy and loses its power because Bitcoin, an example of cryptocurrency, that is VDA, is in a blockchain technology which cannot be regulated by any other authorities, centralized authorities. And it is also a threat to the business of central bank. The government controls the country's finance and economy with the help of central banks and financial institutions. After VDA has become the mainstream, many central banks have lost their business, which is eventually a loss to the government. And it could also lead to crime concerns due to decentralization and anonymity. More and more criminals are using Bitcoin as a viable method for illegal activities. Cyber criminals are using the Bitcoin platform to steal money from the harmful chemicals. More seriously, terrorist organizations are also involved in Bitcoin transaction for trading weapons. This are one of the biggest crime concerns for which government are legalizing are fearing to legalize cryptocurrencies. By taking these grounds into consideration, the Republic of Parliamento have not yet legalized the framework of VDAs. And it is an we also have to accept this. It is an ambiguous concept. Also, considering the huge population and economy of the country, it is a very difficult task to the government to regulate something like digital asset, digital currency, which is a very new and ambiguous concept to the financial market. With this, I have concluded my arguments. If your lordship doesn't have any questions, may I proceed to my co-counsel to continue?
Just 1 second. Can you tell me the Vodafone case law which you are referring me? I didn't able to find out the which you have referred in your issues, second issues. Have you mentioned it anywhere?
Your lordship, I have not mentioned it in my petition because I have founded it after the submission of my petition. And it is not a case I have referred. It is just I have when it started, when the cryptocurrency issue started, I've just referred it that way.
Fine. And how, as in last question is this?
But if
You have
something
mentioned your
there,
crime.
if something is there,
Yes, please.
Your lordship, may you please pardon the question you asked?
Yeah. Just I'm just asking this: how this is terrorist organization are involved in trading through the bitcoins? If we speak about the Republic of Placento United.
Terrorist organizations are concerned with the because since the these currencies are not centralized and cannot be centralized, this terrorist organizations use it as a motive of exchange of currencies, due to which the government of this country is fearing to tax to legalize digital currency, digital asset, and NFTs.
Suppose an Indian citizen, citizen of this republic, wants to buy some weapons, or there is a culprit mine. How this Bitcoin going to help? Because even though the Bitcoin is not legal or legalized, we even have the money laundering access also. So how this we can capture this thing? Can you just explain? I'm not able to understand that
Indeed,
thing.
your lordship. Indeed, your lordship. The crime concerns due to it is because of the decentralization and anonymity. Yes, there are various modes by which uh, this crime concerns could happen. But if we don't tax the crypto, VDAs, it would result in more and more transactions to someone which the government wouldn't be able to notice. If we at least tax the VDAs, it would result in some exchange of centralized authority, which will help the government to know where the money is actually going.
So, is it necessary to tax it at such an exorbitant percentage? Why 30%?
Yes, Your Lordship, uh, because we need to tax it at such a rate because the threat it is a threat to the central banks of the country. It's a threat to the central banks of the country, which would lead the central banks not to regulate because since it is a decentralized manner of currency, we won't be able to take a track on take a track of the currencies. So this is the reason by which the government has thought of taxing it at the rate of 30%.
Do you rely on certain substantive uh, notifications or uh, where the government is coming out with a reason as to why what are the reasons of imposing a tax of 30%? Is there any document that you substantiate your arguments on?
No, Your Lordship.
Okay.
May
If Your
I
Lordship
transfer the
permit,
argument to respondent to?
yes, Your Lordship.
Please.
Am I audible?
Respondent to, you may begin.
Am I audible?
Your voice is very low.
Am
Please
I
be loud.
audible?
Yeah,
Am I
you are
audible
audible.
now?
Yes.
Okay. Your Lordship and your Ladyship, if I may continue where my co-counsel left. Much obliged, Your Lordship and Ladyship. Your Lordship and your Ladyship, I would be dealing with issue number 2, which states whether or not Section 115 BBH of the Income Tax Act is violative to the Constitution of India. Your Lordship and your Ladyship know the Section 115 BBH of the Income Tax Act does not violate the Constitution of India. Section 115 BBH of the Income Tax Act provides for the taxation of income from the transfer of virtual digital assets. It provides only the provisions as to how virtual digital assets shall be taxed. There is nothing in this given section because of which one's fundamental rights are being infringed. Therefore, there is no violation of the Constitution of India. Moreover, the government has every right to make such laws. The Constitution itself gives the power to the Parliament and state legislature in making law with respect to any of the matters enumerated in List 1, 2, and 3 in the 7th schedule under Article 246 of our Constitution. The Parliament, according to Article 246, the Parliament has the right to make laws on tax on income other than agriculture income as given in Union List in the 7th schedule. Also, the state legislature has the right to make laws on taxes on professions, trades, callings, and employments as given under state list in the 7th schedule. As the insertion of section 115 BBH is constitutionally made, therefore the section is not at all violative of the constitution of any article. It is not at all infringing any citizens' fundamental rights. Also, considering the citizens' concern, uh, the citizens are more concerned about how VDAs are being unregulated and still they are being taxed. As my co-counsel stated that the even if the framework of digital assets being unregularized doesn't make the assets illegal as well. The digital assets are in the gray area. They are not legal, and they are neither legal and they're neither illegal. And even if we consider the digital assets as illegal, the imposition of tax has nothing to do with its legal or illegal nature. Uh, Illegality or wrongdoing associated with income, profits, and gains is immaterial for the purpose of taxation. Even if a trade is illegal, it is still a trade within the meaning of the act, and its income, profits, and gains rate chargeable with income tax. So even if we assume that trading and business in digital assets is illegal, imposition of tax still comes under the view as the primary function of the Income Tax Act is to bring the income of various kinds into the tax net, as my co-counsel mentioned. Also, if we, uh, I'm sorry, Your Lordship, also if we look at Article 28, which states that freedom as to attendance, I'm really sorry, Your Lordship. Uh, Your Lordship, I'll continue. Your Lordship, if you look at Article 38 of our Constitution, which states that state to secure a social order for the promotion of welfare of the people, in which the clause 1 states that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which uh, justice, social, economic, and political shall inform all the institutions of the country, which basically means that the government is trying to keep a balance between the wealth of the nation. So, uh, if we consider this point, the government is making tax which can be used in social welfare. So, that's it, Your Lordship. And I would like to conclude it that the fact that before, when there was no such taxation on virtual digital assets, we still saw immense growth in this virtual digital assets, this digital currencies and digital assets. But at that time, people were not at all concerned. People were still using this unregulated and not so secured digital assets. But when the government imposed taxation on such digital assets and digital currencies, the people started to the very uh, I mean the very uh, provision of the taxation started become problematic to the citizens, which is really contradictory because at first they were using these digital assets and digital currencies which were not at all regulated, which were not at all considered, but still they now as there is taxation provisions on it, they have a problem with not the regulation, but at first they didn't. So this is contradictory. Your Lordship, I would like to sum up with prayers. May I proceed with the prayers?
What is your argument to the colorable legislation that has been taken by the other side?
Colorable legislation in what sense? As
The argument that was taken, yes, huh?
the colorable legislature.
Yeah. What is your argument to that? The first argument that was taken by the other side was regarding the colorable legislation. What is your response to that?
Your ladyship, I really didn't understood what the colorable legislature, the petitioner side said. So
Okay, so all right. Okay,
If
thank you.
your ladyship will explain it,
So
I would like.
the other side's argument was so that colorable legislation is uh, a power that is exercised indirectly when it is not being able to exercised in a direct manner. So indirectly, just to ban the practice of cryptocurrency, the taxation of 30% has been imposed by the government.
So, your ladyship, it is not like indirectly they are banning, they are trying to ban. The government never restricted on using these digital assets and digital currencies. They have imposed taxation because there was many people were using these digital assets and digital currencies, and your lordship might be aware how much income is generated through this, and uh, uh, imposing 30% tax is, I mean, justified because the amount of income which is generated because of these assets is really very large, and 30% is quite good enough to impose tax. Uh, Taxation of 30% is quite justifiable to these, to such assets which are traded and income are generated at very large. So yeah.
Okay, thank you.
Uh, Speaker two, I have a questions with the same topic. So, as you were telling me and to us also about imposing the tax and trading the tax, this imposing tax and trading amount. So, how this Article 38 is been justifying with 246? Having said, why not 30%? Why it's 30%? Why not it's 25%? Why it's not 50%? First question. Second, how would you clarify the person is been trading and is trading in the white collar area, not in the gray or collar area, black area? Yes, you're just imposing the tax. Okay, you're earning this much, I'll impose this much tax. How will I clarify that this will be used in good way or good bad manner? I'm just imposing a tax. That's it. So how can you justify the social income with this Article 38 and all those things justification of this 246?
Article 38 basically talks about states about the social welfare. So taxation is used for social welfare, of course, and about the income generated with cryptocurrencies and digital assets, uh, which like your lordship mentioned that we do not know that it comes in a gray area, like how it has been used, and that is the main reason because of these digital assets, not these digital assets um, maybe might be used in a very like corruptive way. Many So much black money can be generated from these such types of assets, and that is why the government has implemented tax on it. And about the question you just ask your lordship about why not 50% or why not 25%, the government must have thought about something, and that is why they have implemented the exactly 30%. uh,
Okay.
your lordship, may I continue? May I proceed with the prayers? Much obliged, your lordship. um, uh, your lordship, whereof in the light of the facts stated, issued, raised, argument advanced, and authorities cited, it is most humbly prayed by the petitioner before the Honorable Supreme Court of the Republic of Parliamento to adjudge and declare the writ petition filed by petitioners XYZ to be declared non-maintainable, that the taxation policy imposed by the government does not violate any of the article of the Constitution of India, and hence the government shall deem to continue the taxation policy on virtual digital assets.
Courtmaster, how much time we left with it?
They are still left with 3 minutes. The previous, after adding the previous minutes, the respondents are left with 3 minutes and petitioners are left with 5 minutes. In
And the
total,
rebuttal after which?
they can present the
Lordships,
rebuttals.
can we proceed with the rebuttal?
Sure.
So, with respect to the arguments advanced by my learned opponents, we have three basic questions which we would like to pose to them in this rebuttal rounds. So, firstly, it's regarding the legislative competency. The council contended that two provisions, basically entry 82 as well as entry 60. In which it stated that so one comes under the union list, another comes under the state list. It's a general principle that the center cannot make laws and infringe upon the matters imposed under the state list. However, the council contended that the parliament will have the power to even impose this taxation regime, which is a central law, through matters which are coming under second list, under entry 60. Then secondly, the council contended that no central regulation will be possible due to the nature of cryptocurrencies and NFTs. However, as it is known that the Republic of Parlamento is a well-established nation, even the international forum, and it has great economic relations with other countries abroad. In countries like Canada, USA, Tokyo, etc., the central system has regulated cryptocurrencies and bitcoins, etc., where they are not legal tenders per se, but their position have been recognized and they have been taxed accordingly. With respect to the argument relating to Article 38, we would like to pose one question to clarify. We seek clarification of the government regarding whether this taxation which they are imposing is a form of compensatory tax or not.
May I, Your Lordship?
Yes, yes.
Okay. So the first question which was asked by the opponents, that how the entry 60, it's just that I have mentioned entry 60 in case which is related to Article 246. I have just mentioned it. It is not related to it, but in case for more information, I have mentioned it. And about the no centralization of the legislature, the cryptocurrency itself was created because cryptocurrency was created uh, so that no third party can be interrupted, and the government has nothing to do with it, but government has imposed tax on it because the income generated from it is very large, and that income can be used for social welfare. Can may I proceed with the sir rebuttal, Your Lordship?
Yes, yes.
I'm much obliged, Your Lordship. So, Your Lordship, our opponents just stated that the taxation which was implemented, and like the digital assets and digital currencies, they were not regularized, and but still taxation policy was implemented, and uh, our opponent stated that it is unreasonable and illogical, that how it is possible. And the second question is that how Article 14 is related, how Section 115 BBH exactly infringed Article 14, which states equality before law. Yes, Your Lordship.
Can you again repeat that section 115, how it's violate Article 14? Can you explain it a bit more?
My question is how exactly Section 115 BBH of the Income Tax Act violates Article 14 of Constitution of India?
If your lordships may permit to answer the questions first. So with respect to the first question, the council is just stating that through the previous conduct of the government. So if we take a historical background right from 2013, so 2013 is the point of time where cryptocurrencies were starting to emerge in India. So in 2013, the RBI issued its first circular, which basically cautioned the users of cryptocurrencies. Thereafter, committee reports and other interministerial meetings were taken place. And then again in 2017, the RBI issued another circular. And then in 2017, an interministerial committee established by the Department of Finance, Ministry of Economic Affairs was to discuss about the whole issue of cryptocurrencies. And in 2018, it came out with a proposal to ban cryptocurrencies. And the same was taken up by the government, and the draft bill on the banning of cryptocurrencies and virtual digital asset was to be implemented. However, by that time in 2018, RBI issued another circular which prohibited the dealing of virtual digital assets by entities which were regulated by it. And through that, that particular circular was contested in the Honorable Supreme Court through the Internet and Mobile Association versus the Reserve Bank of India case, where the Supreme Court ultimately held that circular to be unconstitutional. So therefore, the previous intent up to 2019 has been to ban cryptocurrencies. However, because the government has to follow the judgment and abide by the judgment of the Honorable Supreme Court, it could not introduce a banning provision, and thereafter it undertook to draft new policies, etc. But rather, it just came out with a mere provision, Section 115 BBH, which just aims at imposing an unreasonable tax. So coming to the second point, which is in relation with Article 14.
No,
So
I
our
just want to stop you here for the first question itself. So,
Yeah,
are you
yes,
sure in 2018 it came up with a ban? Are
Your
you
Lordship,
much
the draft bill was completed. However,
not been passed?
no, it was not introduced because the Honorable Supreme Court came out with a judgment, so it could
Fine.
not
That was
pass
a
through.
proposal which is not even tabled also.
Yeah, it was not tabled in the House.
Fine. So we cannot be going through the banning purpose, right? So
Yeah,
from first question, I can see and relate that from since 2013 till 2000, this coming 115, this section, the government was behind the scenes. RBI was behind. They were implementing the circulars. They were working on it, right? Sometimes they say it should be banned. Sometimes they say they should be precaution should be taken care of while dealing with such assets and currency. Am I right? Right.
Your Lordship.
So from we can take this from 7-10 years the government was working on it behind it, and afterwards they came with this 115 after all research and works and all this. Can we say it like
Uh,
this?
Your Lordship, the petitioners are not per se against the taxing regime which is being imposed, but the unreasonable amount of tax which is being imposed without giving any justifiable reasons. So even in the statement of objects and reasons which are given by the government in the Finance Act of 2022, it has just merely stated the imposition of the tax, but has not provided any justifiable reason for imposing the tax and arriving at such a 30% quantification.
Here I have a question for you.
Your Lordship.
Do you, I mean, do you agree with the fact that the gain in cryptocurrency is way higher than a regular taxable source?
Your Lordship, it differs from the type of assets.
Mm.
So that is again, so with respect to the type of assets, that was my answer to the second question raised. So if I may be allowed to club these two and answer them together.
Yes, please.
So I'll just quickly, I'll just counter my learned opponent. So with respect to Article 14 violation, we are going through the unreasonable classification, which is under Article 14. And as my co-counsel has already stated, the colorable exercise of legislation. So with respect to the unreasonable classification, the government has brought under various assets under virtual digital assets. So this definition of virtual digital assets has been provided under Section 2, Clause 47A of the Income Tax Act. Where it gives a very wide power to the government to include any type of assets, which is, going through a cryptographic way or a digital way. And if we look at the very nature of a cryptocurrency and an NFT, they both are different. So you cannot quantify them in the same manner because the value ascertained to them and the underlying value of those assets are completely different. Therefore, it is unreasonable in that way. And also, as my co-counsel stated, there's a colorable exercise of legislation with this entire taxing policy. Now, coming to what my ladyship was asking, ma'am, if
Yes,
possible, could you
yes.
just,
I am just rephrasing my question here. So, if there's a 30% tax to cryptocurrencies, the gains are not similar to the normal source of taxable incomes, right? So I want an answer here that how do you rely on Article 14 when the sources through which the income is being the tax is being imposed, they are at different parlance. You can't keep it the same. The gains in the cryptocurrencies are way higher than the normal sources of income. So why the government should not impose a higher tax to it? This is my question.
Your ladyship, it is to be noted that it's not clear as of now under which head cryptocurrencies are to be taxed. So only if it is clear whether it is to be taxed as a capital gain, as a business income, as other sources, or as ancillary income, then only we'll be able to understand and compare the gains between cryptocurrencies in that particular, whether it is a capital gain or a business income, with respect to other incomes in the same area, Your Lordship.
In any case, the taxability has to be decided on the gains, on the profits that you make out of that income, right? Do you agree to that?
Indeed.
Okay.
And it's very highly volatile also. So as the ladyship said, why we cannot have higher taxes on it?
Your Lordship, if we, my co-counsel, if he wants to.
This constitution with the petition is answering, Lordship. The gains is much higher in cryptocurrencies than other securities. I don't think it's that sure, as in the gains in cryptocurrencies is much more higher than in any other securities. And Lordship, with respect to your question of volatility, there are other assets like future and option assets. There are margin trading. So these are much more volatile than crypto assets itself because margin involves you borrowing from the broker itself. So crypto assets are not that much volatile. While it is volatile, but it is comparable to other volatile regulated assets such as future and options and other regulated and other securities which are taxed at a much lower rate. Lordship, am I audible?
Yes, it's you. Are you?
Yeah, that's all, Your Lordship. That's the Council 2 wants to enunciate that with regard to its gains, it can be varied at different instances, and we can't say that a cryptocurrency has a much more gain than normal securities, Your Lordship. It depends on various situations. Yes. And regard to volatility as well, as I mentioned, there are other volatile assets which are regulated and are taxed at much lower rates.
So if we take it as in the capital gain, which has been discussed right now, so capital gain comes in the 30% brackets as per the normal tax rule. Is it or not? As you are aware?
Yes, but it's again differentiated between long-term and short-term capital assets with regard to their holdings. But again, there's no differentiation in PDAs itself. And further, there is also a set of provisions for the capital gain loss. And in case of a loss in business or profession, it's again a set of carry forward provision is given, Your Lordship. Hence, even if we treat it as a capital gain or the gain from business asset, the explicit disallowance of set of carry forward is violative of Article 14 in the sense that when it is treated in a similar income such as a capital gain or a business gain from business income, the disallowance is quite arbitrary. That's the main contention for the petition, Your Lordship.
Any other rebuttals you have?
Time is up for the petitioner side, but you may continue to ask question if you want to, judges.
No. For the respondent side, I'm asking.
Respondent, do you want to present your rebuttals? Respondent number 2.
I have a question for respondent 1, speaker 1.
Respondent speaker 1, you may unmute yourself.
Indeed, Your Lordship.
I was going through your drafting and all those things. So which you have, as before also, I have spoken with you regarding crimes, other transactions. So you have not able to clarify why. See, taxation, imposing the tax is like 30%. We have mentioned it as per the law, as per 82 of the 7 schedule list and all 246. So fine, you have the money, you can impose a tax on it, and you can and get to accordingly justify the income as Speaker 2 has mentioned earlier. But you have not able to mention or clarify the trading of it. How you will scrutinize the trading, how they are trading, what purpose they are trading, which platform they are trading, where they are using this trading money. Okay, you got the money, I have to impose 30%. But suppose I have the money, I have 1 lakh of Bitcoin, right? I exchange it, I got it, suppose deduction all those 80,000. In my account, I got 80,000. On 80,000, I have to be pay 30%, right? For the rest, I can trade anyway, even in the crime also, on the dark web also. Am I audible?
Your Lordship, your voice is shortly breaking, due to which I wasn't being able to understand your question. May you please pardon your questions, Your Lordship?
Am I audible to you?
Yes, Your Lordship.
So I was asking about imposing a tax and about trading about this thing. So you have came up with this 115BH and Article 246 under section schedule of 82 for the union to make the list 1. So you also spoke about this, why we need to regularize this thing so that we can stop illegal activities. Yes, you mentioned that thing in your draft, that we need to stop illegal activities. We need to centralize this thing. That's why we are bringing this tax law. Yes.
I'm extremely sorry, Your Lordship. Your voice.
Can I have a speaker 2 on this?
Your Lordship, you're not quite audible.
Okay, fine.
I
No
was not
issues.
able to-
No issues. No issues.
Can your Lordship please repeat the question?
First of all, am I audible to you right now?
Right now, your Lordship is audible, but in between your voice, your Lordship's voice is breaking.
Simple is how are you going to trade? The imposition of tax has been implemented, but what about the trading of this currency? How you going to scrutinize it?
What your Lordship meant is taxation is another thing, and trading in cryptocurrency is another thing, because trading is dependent on the person who is engaging in those digital assets and digital currencies. And the taxation is implemented on that individual who is trading and investing in that digital assets or digital currencies.
So what's falling from the Lordship is the question, let me reframe it this way, that one of the reasons that high taxation has been imposed, high tax has been imposed in cryptocurrencies that has been cited from your side is the indulgence into wrong activities, right? So now the question that's coming from my lords is how those activities are going to be scrutinized. How is the government going to keep a track, or how those activities will be scrutinized basis which the tax has been imposed?
Your ladyship, as we know that cryptocurrencies are decentralized, so it is really very difficult for the government to keep a track on how the money, how the income is being used. And this is the reason why it is not legalized. This is one of the reasons why the government has not yet legalized the framework. And the taxation, the government can the government can prevent as much as wrongdoings it can.
But
The
let me stop you here. You're saying that government has not legalized it, but where does it say that cryptocurrency is illegal?
No, it doesn't. The what a thing being illegal means it is forbidden by the government. The government has not forbidden in using cryptocurrencies, so it is not illegal. But it is not. It has not been given. The framework is not legalized.
If it is not
Cryptocurrency,
legalized, how is it under a statute of 247A?
the 247A of the income tax, 240 section 2 of
247A,
47,
right?
section 2 clause 47E. It just states
Right.
the definition of virtual digital assets, like what comes under virtual digital assets. For the government has imposed tax, the government has explained on what thing or on which assets the tax is to be imposed. And because the government has given an explanation that on virtual digital assets the tax has been imposed, and the government has given the definition of virtual digital assets.
It's but can I rightly say that it is neither legal nor illegal? It is still occupying that gray space that you're saying, right?
Yeah, yes, your ladyship.
Hmm.
Cryptocurrencies, digital assets, and digital currencies are still in gray area. Even the government has not legalized it. But to stop such activities, the government has imposed taxes, and the income which is generated is so large that because of which the government has to impose tax.
All right.
It's just time is up for both the sides, but you may ask any questions if you want.
I think I don't have any more questions. Thank you.
Okay, so before we end up this session, I would request on behalf of the advocate Manav Gisil sir to judges for giving feedback on the speakers.
So we need to give the feedback right now.
Yes, feedback to the speakers so
Fine,
that they
so-
can improve their performance in future proceedings.
Right.
Okay.
So all the speakers, I'll tell you one thing. If you don't know the answer, then be confident while saying that wrong also. But never say at least wrong. But you say, "Ki, Lordship, I'm not able to get it back or give us a time." But be confident while speaking up. Second, I would prefer while drafting, I've seen the petitioner sites. You drafted very well, but citations you need to make it, which you are lacking in this issue one. So next time, please make sure that you don't forget these things, because you cannot say I'm lack of time and all those things. That's it.
Thank you.
Yes, so like I said, I mean, like the Lordship also has said that just I'm sure you cannot make a wrong submission in the court, but whatever you have to present it quite confidently. And yes, there was little difficulty in the citations, but all the four councils have done a good job.
Thank you for your
Thank you for
valuable
your-
feedbacks.